So now it's my pleasure, very, very big pleasure, to introduce the person who's going to be introducing tonight's speaker. She made her first appearance at the Cooley Gala last year. We were very excited to have her here last year, and she and the introduction of her was a major deal. But for those of you who don't know, and of course the students here are in the room, all do know because they've seen her perform this week. She has now joined me as a colleague on the faculty of the Georgetown University Law Center, where I've been desperate for originalist companionship, and she has been very happy at providing that, and has become a leader of the Georgetown Center for the Constitution, assuming the position of co-faculty director with me. And she has basically expanded our program because I was basically maxed out. But we couldn't do any more. I couldn't do any more. And as soon as she came on board, she now starts new programs. And she has brought an incredible energy to the Georgetown Center for the Constitution, and even more important to me, secured its future. She is obviously somebody who can step in and run the center for a very long time to come. She's already running the center in major ways, and I just couldn't be more thrilled to have her as a colleague and to learn from her scholarship, which the students had the pleasure of hearing about today. But it has had a big impact already on me. I give a speech to the Federal Society student chapters every year, and this year's speech was basically based on the writings of both Judd Campbell, who lectures in our program, and Stephanie Barclay, because these folks are having a big impact on me. And it's sort of unfair, because I remember when I was young, a young scholar, I was so intimidated by all the senior people. And now that I'm a senior scholar, I'm just intimidated by the junior people. So this is just not fair. I don't know, there must have been some point in the middle where I was not intimidated by somebody, but we're past that point. At any rate, Stephanie will come up and introduce tonight's speaker.
Well, thank you, Randy, for that very generous introduction. Thank you to our participants in our summer seminar, for our distinguished guests, and also for our colleague, Larry. This is my first time getting to be here as a faculty member with Randy, officially as part of the team. And if there was ever any doubt before about how strategic and brilliant and effective Randy was, being able to make it possible for me to get hired at Georgetown, I think, is pretty solid evidence. So thank you to Randy for that. And if we could just, for both Randy and Larry, give them a round of applause for the incredible program that they have built. Getting to see that this week, from beginning to end has been special. You have built something really impressive, and we're lucky to all get to be here tonight because of them. There was actually one brief moment where I thought I might have to miss the dinner tonight because my son has a little play that he was participating in his middle school. But Randy was very gracious. We adjusted the schedule a little bit. I went straight from the event we were having. We had the chance to listen to some justices at the Supreme Court today, hopped in an Uber, arrived at the middle school, changed into this. I think some parents thought, yeah, that parent is a little extra. Like, it's just a middle school play. But we made it, and I'm so glad to be here, and so excited to get to introduce our judicial lecture and honor Judge Stras, who is really such an important force in the judiciary. Judge Stras became a judge on the United States Court of Appeals for the 8th Circuit in 2018. Before serving on the 8th Circuit, Judge Stras was an associate justice on the Minnesota Supreme Court. And we think that that's a special connection for tonight, a particularly important one, because as Randy mentioned, the Thomas M. Cooley Book Prize that we just presented honors Thomas Cooley, who was also the longstanding Chief Justice of the Michigan Supreme Court. Prior to becoming a judge, Judge Stras was also a member of the faculty of the University of Minnesota Law School. He's known for being approachable, really witty, has a dry sense of humor, and someone who has been able to look at the law from all of these different angles as an academic, as a Supreme Court justice, now as a federal judge. He received his Bachelor's of Arts degree with highest distinction and his Master's of Business Administration, both from University of Kansas. and I know we have some Kansas fans in the room. That's right. And he also received his law degree from the University of Kansas, where he served as the editor-in-chief of the Criminal Procedure edition of the Kansas Law Review. Following law school, Judge Stras clerked for the Honorable Melvin Brunetti on the Ninth Circuit, then for the Honorable Judge Luttig on the Court of Appeals for the Fourth Circuit, and he has clerked for Justice Thomas on the U.S. Supreme Court. So it's truly a legend, someone who has had broad experience with the law, who has been a courageous defender of the rule of law, of originalism, and it's such a treat for us all to get to hear from him tonight. Please join me in welcoming him to the stage.
Wow, what a beautiful venue to be giving a speech about the Constitution. Thanks to Randy, thanks to Larry, thanks to Stephanie, thanks to everyone who made this possible. I was talking to my table mates and I said, this is gonna be my one big chance to give a speech about the Constitution within the presence of the Constitution, which is a rare thing to do. Congratulations to our book winners. Second Amendment is also one of my favorite areas of law. I'm not going to talk about it tonight, but I urge everyone to read the book. Now, my understanding is that many of you are law students, recent law school graduates, new clerks, participating in the Originalism Seminar. My guess is that most of you, if not all of you, are planning on doing a clerkship at some point, either federal or state court. I'll start by speaking directly to you. Clerking is the best job you will ever have, bar none. I'm serious. You will learn as much in 1 year of clerking as you did in law school, or at least I did. So I decided to do the next best thing as a career, which is become a judge. Whatever you end up deciding to do, having clerked will make you better at it. Not to mention that you'll make lifelong connections with your judge and their clerk network. Speaking of courts, that's exactly what I want to discuss tonight. I've been studying them, serving them, or thinking about them my entire adult life. First as a federal clerk, 3 times. Next as a federal courts professor, then as a state court judge, and finally as a federal circuit judge. You might imagine that I have a few thoughts on the subject. Tonight, for the next 30 or so minutes, and I'm going to try to keep it under 30 minutes, you'll get to hear some of those thoughts. Having served in multiple roles, I want to help you understand how state and federal courts fit together, including pointing out a few places where we have deviated from the vision of our founders. Tonight's talk is all about maintaining judicial structure. First, the big picture. Call this part the review session. The original Constitution is mostly structural. The founders knew that a government of limited powers is what protects liberty, so they started there. We have a horizontal separation of powers that allocates those limited powers among the 3 branches of government: the executive, the legislative, and the judicial. The remaining powers stay with the states, ensuring a vertical separation of powers as well. As James Madison wrote in Federalist 45, the powers designated by the proposed Constitution to the federal government are few and defined. Those that are to remain in the state governments are numerous and indefinite. Multiple redundancies in plain English, what we call checks and balances, would protect liberty. Only later in the Bill of Rights did the founders focus on individual protections, like the right to a jury trial, the right to confront one's accusers, and the right to associate with others. They knew they had to get the structure right, or the rest simply would not matter. Those constitutionally protected rights needed someone, something to protect them. Each of the 3 branches play their own special role, but I want to focus on the one I know the best, which is the judiciary. All right, the review session is over. Now let's start at the very beginning, which may sound contradictory. I promise you it's not. No, we don't start with the Constitution, but with its precursor, the Articles of Confederation. Under it, there was no federal judiciary, no Supreme Court. It's really hard to imagine today, with so many interstate disputes in a modern economy, that the parties had to pick a state court with all of their local biases and try to resolve their disputes. And sometimes, unsurprisingly, it didn't work. Parties would file in multiple courts, which could result in conflicting determinations about their rights and obligations, creating what is scientifically called a real mess. So by the time of the Constitution's ratifying convention, many saw the need for at least a Supreme Court, a national Supreme Court. Division brewed, however, about whether to create inferior federal courts too. On one side were John Rutledge of South Carolina and Roger Sherman of Connecticut. They strongly opposed the creation of inferior federal courts. They viewed them as an unnecessary expense. I disagree. They also viewed them as a potential threat to the primacy of state courts. That one might be a little more legitimate. Luther Martin of Maryland echoed similar concerns and stated that federal courts would create jealousies as the country grew. In the opponent's view, why not just rely on the courts that already existed, the courts we had with the Articles of Confederation, instead of creating new ones? There would, after all, be one single Supreme Court to decide all the disputes involving federal law that came out of those state courts. Oh my, how different the country would look today if Rutledge, Sherman, and Martin would have had their way. I venture to guess, for one thing, that the Supreme Court would be hearing a lot more than 55 to 60 cases per year on its plenary docket. And I'd still be on the Minnesota Supreme Court. On the other side of the debate were James Madison and Edmund Randolph, both from Virginia. They wanted the Constitution to create lower federal courts from the very beginning. Madison thought that a single Supreme Court would run into state court stonewalling, because on remand, state courts could just re-implement or reinstitute their judgments. In Federalist 81, Alexander Hamilton made a similar observation. He worried that the local spirit of some state courts would disqualify them for the jurisdiction of national causes. For Madison, Randolph, and Hamilton, inferior courts would also stand between out-of-state parties and the inherent bias of state courts and local juries, why we have diversity jurisdiction today. Those fears may sound quaint to modern ears, but they were very real to the founders. For one thing, interstate travel was a difficult ordeal. Think of the Supreme Court justices who rode circuit during the early years of our nation. Once, all 6 Supreme Court justices wrote a letter to President Washington complaining about the hardships they endured. They described the burden as so excessive that they cannot forbear representing them in strong and explicit terms. They went on to say that existing in exile from their families and of being subjected to the kind of life on which they cannot reflect without experiencing sensations and emotions more easy to conceive than proper for them to express. They really didn't like it. Indeed, one justice, Justice Stephen Field, was almost shot by an unhappy litigant while he was traveling in California, and many other justices had harrowing experiences along the way. Another problem was the different customs, currencies, and laws around the nation. Ben Franklin recounted a 3-day journey from Boston to Philadelphia as a runaway at the age of 17. The simple act of buying bread, familiar to many of us, was a wholly foreign experience to him. And I'm going to read this. I asked for a biscuit, intending such as we had in Boston, but it seems they were not made in Philadelphia. Then I asked for a 3-penny loaf and was told they had none such. So not considering or knowing the difference of money and the greater cheapness nor the names of his bread, I bade him give me 3 penny worth of any sort. He gave me accordingly 3 great puffy rolls. I was surprised at the quantity, but I took it. Having no room in my pockets, I walked off with a roll under each arm and eating the other. Now imagine, if you will, that this bread buying experience took a turn for the worse, and the baker wanted to take young Ben Franklin to court. If buying bread was a daunting task, surely navigating a foreign and potentially hostile court would be truly overwhelming. A neutral federal forum, on the other hand, would still likely be alarming to Ben Franklin, but it made a lot of sense in these circumstances. Still, for those fearful that the federal courts would overwhelm their state counterparts, the risks outweighed the benefits. So Madison, ever the clever politician, met his opponents halfway. Now known as the Madisonian Compromise, the plan left the creation of inferior federal courts to Congress for later. We would have one national Supreme Court, but anything more would be Congress's call. Not only whether inferior federal courts would exist, but what their jurisdiction would be. We'd have none of the mess accompanying the Articles of Confederation, or at least that was the idea. Now, the genius of the original structure was its simplicity. The Supreme Court retains original jurisdiction in limited categories of cases, state versus state, cases involving ambassadors, list goes on, with appellate jurisdiction over everything else within the judicial power of the United States. Congress could then see how everything worked and create inferior federal courts down the line if needed. And state courts would still have a large role to play, particularly in adjudicating intra-state disputes. What an elegant solution, given that state courts would continue to do what they already knew how to do. Madison got his wish, better late than never, when Congress passed the Judiciary Act of 1789. It created 13 federal district courts, one for each state, with a single district judge in each district. Congress also established 3 regional circuit courts. They went by a different name: the Eastern, the Middle, and the Southern districts. Or circuits, excuse me. Circuit courts were very different back then. They were staffed with a single district judge from within the circuit and 2 Supreme Court justices writing circuit. We've already talked about that. Although the practice of circuit writing no longer exists, much to my chagrin, the original structure foreshadowed how federal courts would eventually look. Replace district judges and Supreme Court justices with circuit judges like me, and we finally get to how I exist, thank goodness. Here's the main thing I hope you take away from tonight. The original structure of the judiciary, the Madisonian Compromise, protects 2 important principles, and we're going to return to these over and over again. First, federalism. State courts continue to play a role in hearing the vast majority of cases. And by vast majority, I mean vast majority. For perspective, my home state of Minnesota has 289 state trial court judgeships and just 7 authorized federal district judgeships. Those 7, as incredibly hard as they work, don't work 42 times harder than the state trial judges. The reason is that the bread and butter of judicial work happens in state courts. Family law, probate, property dispute, petty crimes, those are all state court matters, and the list goes on and on. Second, the separation of powers. That is, to the extent we have federal courts, Congress gets to make them and decide what cases they hear. In other words, the same structural protections that are woven throughout the Constitution are imbued in the structure of the judiciary. Throughout my remarks, we'll come back to this. With the table setting over, let's get into specifics. This is the exciting part. What is working well today? What isn't? Where have things broken down? And ultimately, how can we get back to the original structure, judicial structure, the founders had in mind? Let's start with the bad and end on a good note. The idea behind the Madisonian Compromise was to give federal and state courts their own lanes. These days, however, the lines between them get blurred. I have 3 examples in mind. The first is so-called arising under jurisdiction, most recently expanded in a case called Grable. As we all know, or most of us know, the Constitution permits federal courts to hear cases arising under the Constitution, laws, and treaties of the United States. That seems pretty straightforward to me. If the Constitution, a federal law, or a treaty creates the cause of action, federal jurisdiction exists. Yet, for more than 100 years, the Supreme Court has vacillated between 2 extremes. The first, what's called the creation test, comes from a 1916 case called American Well Works versus Bowler. It premises federal question jurisdiction on the law that creates the cause of action. And then, just 5 years later, talk about a wild swing, the Supreme Court went back to the other extreme in Smith versus Kansas City Title and Trust. It recognized federal question jurisdiction for state law causes of action when the right to relief depends upon the construction or application of federal law. Since then, and I used to be a Fed courts professor, the pendulum has been swinging back and forth. From Merrill Dow's American Well Works-like test to Franchise Tax Board's Smith-like test. Grable was supposed to fix things. Instead, we received an exceedingly difficult 4-part test. In order for a question to arise under federal law, it must, 1, necessarily raise a stated federal issue, 2, that is substantial, 3, that is actually disputed, and 4, this is the kicker, capable of resolution without disturbing any congressionally approved balance of federal and state judicial responsibilities. That's a mouthful, and like most multi-part tests, it's about as clear as mud. Divorced from the text of the Constitution and the federal question jurisdiction statute, it lets a lot more cases into federal court than it should. For starters, how do we determine whether a federal question is substantial? That should be the easy part. It's invariably substantial to the parties, or else they wouldn't be in court litigating it. But that can't be it. The point here is that pinning down substantiality is often in the eye of the beholder, which is hardly a principled way to make jurisdictional judgments. By the time we get to the 4th requirement, we have to ask whether giving the parties a federal form, I'm going to repeat this, will disturb the congressionally approved balance of federal and state judicial responsibilities. Good luck with that one. I have a hard time figuring out what type of case will disturb the congressionally approved balance, and I have held both jobs and co-authored a federal court's casebook. You know who is well-positioned to make these determinations? Congress. The very branch of government that the founders decided should make the call about whether inferior federal courts should exist at all. Why not just stick to the federal question jurisdiction statute that Congress first gave us in 1875? The Grable test, after all, in that 4th prong, acknowledges that Congress is supposed to allocate jurisdiction between state and federal courts. I may be stating the obvious, but didn't it do that already 150 years ago? Profound, I know, but why not just follow the statute? Sure, my current job would end up being a little less interesting, But why not return to the simplicity and textual grounding of American well works? A legal question arises under the law that creates it. It could be that simple. Unfortunately, other areas of the law are just as complicated. Consider the completely unoriginalist doctrine of complete preemption. Some statutes are so powerful in the court's eyes that they both preempt state law and provide a ticket into federal court, all without Congress or the parties saying so. It is the ultimate jurisdictional trump card. Wait, you say, everyone knows that the Constitution has the supremacy clause, and that allows federal law to preempt state law. But the complete preemption doctrine is a different animal. It extends that preemptive effect to create federal jurisdiction where none exists. Preemption, after all, is normally a defense to a state law claim, not a cause of action of its own. In the typical situation, we look to the fact of a well-pleaded complaint and see whether a federal issue appears on it. If not, the case stays in state court, even if it is painfully obvious that the whole case will end up being about a defense that the defendant raises, like preemption. The well-pleaded complaint rule allows federal and state courts to each remain in their respective lanes. Complete preemption, just like the Grable Doctrine, upsets the Madisonian Compromise by providing an on-ramp into federal court for cases that shouldn't be there. It all started, well, not all started, but complete preemption started in 1968 in Avco Corporation versus Arrow Lodge number 735. An employer sued in state court to stop a union from striking at one of its facilities. Its sole claim was for state law breach of contract based on a collective bargaining agreement. Even if the union wanted to raise a preemption defense, it should not have created federal jurisdiction, or so everyone thought. The Supreme Court, in an opinion authored by Justice Bill Douglas, went the other way on the theory that the Labor Management Relations Act, which governs employer-union relations, completely preempts the state law cause of action. And over the next 40 years, courts expanded the doctrine to include other statutes. ERISA, the National Bank Act in a case decided the term I clerked, and each time the rationale was basically the same. Some federal statutes are just so powerful that they displace those state law causes of actions that come up in the same neighborhood. I can't help but wonder whether the Supreme Court really just thought that these areas are too federal for state judges to understand. Maybe they couldn't handle it. Rutledge, Sherman, and Martin, the opponents of a powerful federal judiciary, were turning in their graves. The Anti-Federalists, however, saw it coming. Brutus once remarked, "In the course of human events, it is to be expected that they," meaning the federal courts, "will swallow up all the powers of the courts in the respective states." What an accurate way to describe the effect of complete preemption. In those areas, federal law literally swallows up state law, leaving state courts in the cold. Justice Scalia would echo Brutus's concerns in his beneficial national bank dissent. There, he recognized that complete preemption represented a sharp break from our long tradition of respect for the autonomy and authority of state courts. Keep in mind what I told you at the very beginning. Without the Judiciary Act of 1789, we would have no inferior federal courts. And labor relations cases are not within the original jurisdiction of the Supreme Court. So I ask you a question. How can it possibly be that only inferior federal courts, those created by the grace of Congress, are the only ones that can hear them? It makes no sense. And it doesn't align with the principles of our great structural Constitution. Now, I just gave you two examples of cases that creep into federal court, even when they really belong in state court. at least if we followed the structure of the original Constitution. In some cases, however, the problem runs in the other direction. I'm talking about cases that are currently stuck in state court that should really be in federal court. I'll use a recent case of mine as an example. My home state of Minnesota sued some energy producers in state court for violating state consumer protection laws. Except there's a catch. The suit was based on global, and I stress global greenhouse emissions. And Minnesota was explicit in what it wanted, for the companies to reduce their worldwide energy production to lessen pollution and reduce emissions. In other words, because Minnesota felt strongly about climate change, it wanted state courts in Minnesota to find a global solution for the problem. And make no mistake, Minnesota is not alone in bringing this type of lawsuit. Many states are currently bringing similar lawsuits all over the country. When the energy companies tried to remove the case to federal court, the district court had to send it back, and we had no choice but to affirm on appeal under current doctrine. There was nothing we could do. The suit nominally arose under state law, and even under the theories I've discussed tonight, like complete preemption and Grable, there was simply no federal question present on the face of the complaint, even if all of us really knew deep inside that it was really a federal case. So back to state court it went. As I wrote in my concurrence, this result would have profoundly surprised our founders. Although Minnesota was suing a private party, let me pull back the curtain and explain what was really happening. Minnesota was effectively trying to use its own state laws to exact nationwide compliance, right? We're talking about universal injunctions, nationwide compliance from energy companies that operate worldwide. In other words, it was using its own laws and its own courts to dictate energy policy for everyone else. When states try to impose their own standards on other states, things start to get messy again. Recall what Hamilton said in Federalist 81. The local spirit of state courts could disqualify them from jurisdiction over national causes. He must have been talking about these exact cases. That is exactly why disputes of this nature were heard in the first instance by the United States Supreme Court through its original jurisdiction. And in fact, a group of states led by Alabama recently tried to do exactly that, to sue Minnesota and other states directly in the Supreme Court, using original jurisdiction as the hook. The Supreme Court declined to hear the case, but Justice Thomas, joined by Justice Alito, dissented. He observed that the plaintiff states allege that the defendant states are attempting to dictate interstate energy policy through the aggressive use of state court tort lawsuits based on out-of-state conduct with out-of-state effects for the purpose of placing a global carbon tax on the traditional energy industry. Those two justices, in other words, would have allowed the state to proceed as an initial matter in the Supreme Court. And I agree with them because the Supreme Court is exactly where this type of interstate dispute belongs. Let me explain why. When it comes to interstate disputes, what law do you apply? How can one co-equal sovereign use its laws to bind another? Recall the problems with the Articles of Confederation. In the absence of a national court, state courts could apply their own law and create a real tangled web of conflicting rights and obligations. Since then, federal courts have solved this problem by applying federal common law, which at the time of the founding would have been called general law, as a neutral means of adjudicating and addressing these national issues. I think if we were truly being faithful to the original structure, we would recognize that disputes like these are really between states. And when states fight, their claims don't truly arise under state law. But sadly, until Congress or the Supreme Court does something about it, these cases will stay in state court. Now the good news. My sincere hope is that the pendulum is starting to swing the other way. I don't know that I can confidently say we now have an originalist Supreme Court, but here's what I can say. We have a court in which a majority of its justices take originalism seriously. And this court has been sending more issues back to the states. Consider one recent example. The first case argued in October at the Supreme Court this term came from the 8th Circuit. It involved dog food. Anastasia Wolfschlager bought some of it in Missouri from a company called Royal Canin USA. She thought the company had misled consumers by using a prescription label on its dog food, even though it contains no medicine. Her solution was to file an action in state court under the Missouri Merchandising Practices Act and state antitrust law. But in the complaint were some references to federal law, such as the Food, Drug, and Cosmetic Act. Royal Canin removed, on the basis of those references, thought these state claims were really federal claims, and asked the district court to keep it in federal court. Now remember where we started with Smith and Grable in the 3 examples. Except this time, Wolfschlager didn't want to be stuck in federal court, so she did something that was really clever. She removed all references to federal law in the complaint, and then the question for us became, was it too little, too late? The parties thought it was because supplemental jurisdiction, in their view, had already attached. That's pretty technical, but we'll get to the punchline. Not so fast. The 8th Circuit panel I was on was not so sure and asked the parties to discuss whether the case still belonged in federal court. Seems straightforward enough. With no federal questions remaining, Wolfschlager's case belonged in state court, right? Every other circuit had ruled the exact opposite. For post-removal amendments, courts were supposed to look at the original complaint and figure out if jurisdiction existed back then. If it did, then the district court would choose to keep it on a case-by-case basis, even if all federal issues were gone. And even if that meant deciding a case that should otherwise be in state court. Without any directly on-point precedent, I returned to first principles. And those first principles, exactly the ones that I've discussed with you tonight, led me to the right answer. No federal jurisdiction. The case had to be remanded to state court. Not only did other circuits disagree, but my own clerks did too. They said to me, "Judge, how could the panel possibly go against what every other federal circuit had done? And how would we write the opinion?" They pointed out there was even an opinion from one of my judicial heroes, Justice Scalia, that suggested those other circuits might be right. All of those things were true. I told them it was just time to go back to basics, and we did. Now, the most important part of the story. The Supreme Court unanimously agreed. What was clear from the oral argument is that the justices, all of them, went back to first principles. No, they didn't overrule Grable, which Wolfschlager's attorney actually asked them to do. But they reinforced that cases without a federal question and no other basis for federal jurisdiction belong in state court. It may sound elementary, but the Supreme Court reaffirmed that state cases belong in state court. Now I'll admit, not everyone shares my love for jurisdiction. I know that. Some judges even think it stands in the way of getting to the real heart of the dispute, the merits. Sometimes it does, but that is no reason to ignore our constitutional structure. Some disputes belong in state court, and others are up to the political branches. Neither should be in federal court. One small case about dog food might not seem like a big deal, but to founders like Rutledge, Sherman, Martin, Madison, and Hamilton, it mattered profoundly where each and every case would be decided. So yes, even in a case about dog food, jurisdiction matters. And federal courts play their part when they police their own jurisdiction. That is one of the takeaways from tonight's speech. Another is even more foundational. The founders hotly debated how federal and state courts would interact with one another. Each had their own role to play, assuming Congress decided to create inferior federal courts. The system they envisioned was inspired by and imbued with the liberty-protecting principles of federalism and the separation of powers. But keep in mind, we have to be vigilant about maintaining that structure. We have, after all, moved away from the original vision through adopting doctrines like Smith and Grable and complete preemption. I think Justice Thomas, my old boss, realizes it because he regularly starts oral argument these days by asking some variation on this question. He did it the other day in the birthright citizenship cases. He always starts by asking, what are the historical analogs and the historical pedigree of the rule you're asking us to adopt? Exactly the questions we should all be asking. At last, I think there's a reason for great optimism. There are a number of great and inspiring jurists who are now asking the right questions and working hard daily to uphold the system of federalism and separation of powers we have. And then, of course, there are students like you who devote your time to learning and studying the original structure of the Constitution this week. I hope you continue to commit yourselves to upholding it as you embark on your own legal careers. The future gives me optimism. I hope it does for you too. Thank you.
Judge Strauss, thank you so much for that very, very clear. I mean, federal courts is not my thing, and I was able to understand it, and I thought it was just fantastic. We have a small token of our appreciation that we would like to present to you. And now, we scheduled this dinner a little earlier than we have in years past to ensure that you would have enough time to come up and examine our founding documents. We have to vacate the building at 10 o'clock, which means people are going to start being ushered downstairs by around 9:45 or 9:50. So please make your way up here and enjoy this fantastic venue with these fantastic documents behind me. Thanks for coming, and for the students in the audience, I look forward to seeing you tomorrow morning. Thanks.